Good morning. Happy 4th of July.
Good morning.
Good morning.
Good morning. I'm Judge Myers. Can I get appearances there?
Callie Chrysler, Assistant Public Defender. Good morning, Judge.
Good morning.
Officer Jenkins, PTR.
Thank you, Officer.
I have one Spanish speaker just for the court's information. Everybody else is pretty good.
Okay, we'll get them probably at the end. Can you tell me the name?
Mina Oviedo is a warrant case.
Got it. Thank you.
Yes, sir.
And state?
Yes, Gene Almanasi for the state of Florida.
Perfect. Thank you. All right, I'm going to call the names, and if I could, when you get to the microphone, if you would please repeat your name for me. Just tell me your name. Make sure we've got the right person here. Brianna Cameron.
And Your Honor, I do have a probable cause argument for this.
I think I've got it covered.
Yes, sir.
Brianna Cameron.
Thank you. Ms. Cameron, you are here arrested on charges of possession of cocaine, possession of an opium or derivative, 4 grams to under 30 kilograms, possession of meth, 4 grams less than 30 kilograms, and possession of a controlled substance without a prescription, meth, possession of a controlled substance without a prescription, fentanyl, and possession of a controlled substance without a prescription, MDMA. I don't see probable cause for any of the charges in the affidavit that's been filed. There's some indication that there was going to be a supplement, but it does not appear to be attached to the documentation I have. So, Mr. Almanasi?
Yes, Your Honor, I would request 24 to 48 hours to get that supplement in order to determine probable cause, Your Honor.
Okay. Ms. Crystal, are you able to hear that?
Yes, sir, I was.
Okay. All right, I do think it's appropriate under these circumstances. There are bonds set, and so if she wants to bond out, there's got the ability to do that, but I'll carry it over for 48 hours and give the state the opportunity to provide a supplement. Thank you, ma'am.
And is the Public Defender's Office appointed?
Yes, we'll appoint the Public Defender's Office. Thank you.
Thank you, sir.
Your Honor, she's also out on the Orange County case, out on bail 23 CF 2741.
Correct, but I really can't take any action on that case at this point since I'm not finding any probable cause today.
Okay.
Thank you. And thank you, ma'am. Antonio Cruz?
Miss Wonder.
Camera, sir. Antonio Cruz.
Good morning, sir. You are here arrested on charges of petty theft, a first offense. I do find probable cause for the charge. I'll appoint the Public Defender's Office to represent you, and I will stay the bond at $250 with an order that you not return to the Walmart. Thank you, sir.
John?
Yes.
Your Honor, we would ask PTR if he qualifies for direct PTR.
Oh, I apologize. He sure does. Any objections from the state?
No objection.
All right. So direct PTR.
Thank you.
Thank you. No bond then. Thank you. Roberto Diaz
He is still at the hospital, Your Honor.
in the hospital?
Yes, sir.
Okay, we'll reset. It's here on a warrant out of Orange County, so we'll just reset that for tomorrow. I'm sorry, any indication when he'll be out of the hospital?
Any indication when he'll be released from the hospital? There's no indication here.
All right, we'll just reset for tomorrow then. Thank you. Trevor Dolan?
Your Honor, we would waive the reading of the underlying.
All right.
How you doing, Your Honor? Trevor Dolan for the record.
Thank you. Mr. Dan, you're here arrested on a warrant for violation of your probation or community control. Your bond has been set at 0, and we'll appoint the Public Defender's Office to represent you. Thank you, sir.
All right, thank you, Your Honor.
Pierre Evans?
Pierre Evans.
Good afternoon, sir. You were here arrested on charges of selling cocaine within 1,000 feet of a worship center or business. On an affidavit, probable cause was previously determined, and will appoint the public defender's office to represent you. And I will stay your bond at $10,000 on the charge. Thank you, sir. Efrain Mendez Sanchez,
He bonded, sir.
thank you. Alex Miller,
Alex Miller.
Mr. Miller, you're here arrested on charges of battery, domestic violence, and committing domestic violence battery by strangulation. I do find probable cause for the charges, and I'll appoint the public defender's office to represent you. I'm going to set your bond at $1,500 on each of the counts in order that you have no contact whatsoever with the victim, that you may not return to the victim's residence. You must maintain a separate physical residence. You may, if necessary, return one time together with law enforcement to retrieve any personal belongings. And you're not to possess any firearms or weapons. If you have any, they must be surrendered to law enforcement within 24 hours of your release. Okay, thank you, sir. Simone Modica.
Simone Modica.
Thank you, sir. Sir, you're here arrested on a charge of trespass of an occupied structure or conveyance, as well as possession of a controlled substance, fentanyl, possession of a controlled substance without a prescription, fentanyl, and possession of drug paraphernalia. Court does find probable cause for each of the charges, and I'll stay your bonds as set. That's $500 on the trespass, $2,500 on the possession of a controlled substance, fentanyl, possession of a controlled substance without prescription, $1,000, and $500 on the paraphernalia charge. I'll order that you not return to the Circle K where the trespass occurred. I also see that you are out ROR in case number 23 CF 639. Court is going to revoke and discharge your ROR status, order that you be held at no bond on that case. Thank you. Raul Navarro.
Ron Navarro.
Mr. Navarro, you were here arrested on charges of possession of a controlled substance without a prescription, fentanyl, and possession of paraphernalia. I do find probable cause for each of those charges, and I'll appoint the public defender's office to represent you. Stay your bonds at $1,500 and $500 on each of those counts. Order that you not possess or use any illegal drugs. In addition, you were arrested on a warrant for violation of probation.
Your Honor, my client informs me that he had a violation of probation earlier this year and had pled to a credit time served, revoke, and terminate on this case. I don't know if you have any access to be able to check that. I just wish to bring it to the court's attention.
I don't have access right now, I'm sorry, to be able to confirm that, but it obviously makes a difference. Pretrial release, are you able to tell us?
No, sir.
And I don't have a copy of the warrant either.
Yes, Your Honor, could we possibly,
We're gonna look it up.
pretrial is going to look it up.
Great, thank you. 15 and 5. Looks like it's 22 CF 1710.
Yes, sir. One of my coworkers is looking it up now.
Thanks so much.
And Your Honor, if needed, we could reset him for tomorrow, and I will also do a diligent search of what was happening.
I think that would be a good idea. We'll just stay his bond at 0 and reset him for tomorrow unless you learn something. Just on the VOP.
Yes, sir. It actually, I'm looking, it was actually, they printed out. Yes, Your Honor, if we could just reset this for tomorrow, I'll take a look at it.
Okay, very good. Thank you.
Thank you.
Thank you, sir. Oscar Pagan Guadalupe.
I need him to stay.
Wanna hold on?
Yes, please.
Oscar Pagan.
Thank you. Good morning, sir. You are here arrested on a charge of driving with your license suspended or revoked. I do find probable cause for the charge, and I'll appoint the public defender's office to represent you. It looks like he qualifies for direct PTR. Any objections from the state?
No objection.
All right, we'll order you released under the supervision of pretrial release. Thank you.
Thank you.
Samuel Romius.
And the Romius.
Thank you, sir. You're here arrested on charge of petty theft. I do find probable cause for the charge, and I'll appoint the public defender's office to represent you. Looks like you also qualify for direct pretrial release. Any objections?
No objection.
All right, without objection, then you'll be released on direct pretrial release with no return to the Walmart, sir. Thank you. Jonathan Santiago.
Jonathan Santiago.
Thank you, sir. You were here arrested on a warrant for failure to appear on a written promise. I'll appoint the public defender's office to represent you, and your bond is set at 0. Thank you. Jermaine Thomas.
And Your Honor, I have a probable cause argument for this.
Jermaine Thomas.
Thank you, sir. As to which charge?
The fleeing and eluding.
Okay. Mr. Thomas, you were here arrested on 2 charges. The first is fleeing, eluding a law enforcement with lights and sirens active, and second, on resisting arrest without violence. I'll hear the argument now.
Yes, Your Honor, the fleeing and eluding, Mr. Thomas was on a bicycle. It was not a bicycle that was electric. He was pedaling. The officer even mentions that he was pedaling. This is a pure bicycle. And while fleeing and eluding charges are usually done in motor vehicles or some other motorized transportation, we would be asking that no probable cause be found. The lesser included of even resisting without violence, that would be something that would be a more logical charge to this rather than the fleeing and eluding itself on a pedal bicycle.
Okay, from the state?
Yes, Your Honor. Under Florida Statute 316.1935 sub 1, the statute clearly outlines that a vehicle is used in a fleeing and not a motor vehicle. So since the defendant was on a bicycle, which can be defined as a vehicle under the statute, the defendant can still be found guilty of fleeing or
At my own peril, any case law?
Your Honor, I have no case law that I am capable of looking up at this time, as I'm currently in the jail. But again, in vehicle in and of itself is defined in statute. And 1 second, I will pull up that definition.
Your Honor, under Florida statute, my apologies for interrupting the defendant. Under Florida statute 316.003, vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway, except personal delivery vehicles, mobile carriers, and devices used exclusively upon stationary rails or tracks. The state's argument would be that a bicycle falls squarely within the definition of a vehicle under Florida statute.
All right, thank you. I'll find probable cause then as to both of the charges. Appoint the public defender's office to represent you, sir, and I'll stay your bonds as set. On the resisting charge at $500 and set your bond at $500 on the fleeing eluding.
Thank you, sir.
Thank you. Alexis Van Kesteren. Good morning. You are arrested on a warrant for failure to appear. Your bond is set at 0, and I'll appoint the public defender's office if not previously appointed. Thank you. Heather Wetzel.
Heather Wetzel.
Ms. Wetzel, you're here arrested on charges of retail theft, petty theft, drug paraphernalia, possessing paraphernalia, and possessing a controlled substance and another paraphernalia charge. Court does find probable cause for each of the charges. I'll appoint the public defender's office to represent you. And it appears that she qualifies for direct pretrial release. Any objections?
1 second, Your Honor. No objection.
Okay, without objection, then we'll order you that you be released on direct pretrial release. But during this time, ma'am, no return to the Walmart. You're not to possess or consume any illegal drugs, and you'll be randomly tested through pretrial release at your expense. Thank you. All right, let's get the interpreter on the phone. We could have Jahan Mita Oviedo come up.
Good morning.
Walmart. Good morning. We're going to, hang on 1 second, we're going to get the interpreter, sir.
Thank you.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today, Your Honor.
Good morning, thank you. All right, we are handling our initial appearances in Osceola County, and we have a defendant, John Mina Oviedo. Good morning, sir.
Buenos días, señor Mina Oviedo.
Buenos días.
Good morning.
Sir, you were here arrested on charges of obtaining property under $20,000 and engaging in a contractor's business without certification.
Señor, usted está aquí por haber estado involucrado en una transacción de $20,000 o menos y por haber hecho un contrato sin certificación.
Probable cause was previously determined by the court.
El juez había hallado que habían causas que respaldaban la acusación previamente.
I'll appoint the public defender's office to represent you.
Se le designa a la Oficina de Defensores Públicos para que le represente.
For some reason, no bond was set in the capias order, but he's certainly entitled to a bond, correct?
Yes, Your Honor.
El juez se ha preguntado a la fiscal, usted fue detenido sin fianza, pero tiene el derecho a tener una fianza, ¿cierto? Sí, su señoría.
So I'm going to
Gracias.
set your bonds at $1,000 on the first count, $150 on the second count. Order that, consistent with the capias, that you have no contact directly or indirectly with the victim.
Bien, le vamos a estar dando una fianza en la primera causa, $1,000, en la segunda causa, $150, y de acuerdo a la orden de arresto, no puede tener ningún tipo de contacto con la alegada víctima.
You're not to possess or consume any alcohol or illegal drugs or controlled substances without a valid prescription.
No puede poseer ni consumir ningún tipo de drogas ilícitas.
Okay.
And you're not to possess any weapons or firearms.
No puede poseer ningún tipo de armas ni armas de fuego.
And you're not to drive without a valid driver's license.
Tampoco puede manejar sin una licencia válida.
Okay, muchas gracias.
Thank you, sir.
Okay, thank you very much.
Buen día.
Gracias, señor. You have a good day.
Thank you, Madam Interpreter. That's our only case for Osceola. We're going to call back with an orange case in just a moment.
Thank you, Your Honor.
Thank you.
You're welcome.
That's all we have here. Have a good day, Judge.
Excellent. Thank you all as well. Happy 4th.
Happy 4th.
So for the sign interpreter, Ms. Dyer emailed me saying that they're unable.
Brenda Eugene.
Letitia George, on behalf of the Office of Public Defender.
Yeah, I'm up a little too high and I can't reach the microphone. Yeah, that's more comfortable for me to reach a microphone. Oh, they come back, so, yeah, I could just push them back. This thing is, it's a good chair, it's just a little, used, well used, I should say. All right, interpret.
Good afternoon. This is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good afternoon. This is a case involving Clemente Bakirizo, case number 2023 MM 4658AO. And in this case, Mr. Bakirizo, I do find probable cause for the charge of petty theft. And I am appointing the public defender to represent you. Bond will stay set at $250. You're ordered to have no contact with the victim, not return where this incident occurred. You understand, sir?
Yes.
Thank you, sir. Madam Interpreter, I am told that that was the only Spanish case, so thank you for your assistance.
You're welcome, Your Honor. Have a great day.
You do the same.
You too.
Jamie Britton? The court does find probable cause in your case for battery.
Battery?
Yes, Jamie Britton, right, correct? For battery.
I don't want to charge.
I'm ordering you to have no contact with the victim. Also, I'm setting a bond of $500. Ordering you to have no contact with the victim, no return, possess no weapons and no firearms, and surrender all weapons and firearms to law enforcement within 24 hours of release.
Your Honor, I believe this happened at the jail.
It happened in the jail, Your Honor.
And I haven't even been served with a warrant or anything.
So no contact with the victim and no return.
To the jail?
Well, I thought you said Jim.
No.
It was inside.
And so this was the case involving the jail. Yes, I do recall that case. Yeah, I don't know if I can do no contact, no hostile contact, and eliminate the no return.
So you said no hostile?
No hostile contact. And a bond of $500.
Even no weapons and firearms?
No weapons, no firearms, yes, and,
A sign.
thank you, ma'am.
Thank you.
Ronnie Thomas. Mr. Thomas, in your case, the court does find probable cause for the charge of trespass. Is there a plea?
Yes, Your Honor. The offer from the state is an adjudication of guilt, 3 days in the Orange County Jail with credit for 2, and no return to 605 West Colonial Drive. Mr. Ronnie cannot see, Your Honor. We did go over the plea, and he would like to accept.
All right.
and
May I see the
no
plea form?
contest. He couldn't, I don't know if he could sign because he can't see. He's blind.
Well, can you write, sir?
Yeah.
Can you just direct him to where the signature line is?
Yes, sir.
And I will note that for the record, Ms. George reviewed the plea form with the defendant as he is unable to see the plea form on his own.
Yeah.
Mr. Thomas, now, Counsel has said that she reviewed the plea form with you. Is that correct? And were you able to have all your questions answered regarding the plea form to your satisfaction? Can you speak to the microphone? Show them where the microphone is.
Yes.
Okay. And did you just sign this plea form after I asked you to do so in court? Are you under the influence of any alcohol or drugs or medicine? Do you understand that by entering a plea of guilty or no contest, you are giving up all the rights on the plea form? Do you understand that a conviction on this case will subject you to deportation if you're not a U.S. citizen? I've reviewed the plea form, and I find that there is a sufficient factual basis to accept your plea, and you are alert and intelligent. You're adjudicated guilty. You're sentenced to 3 days in jail. Does he have 2 times served?
Yes.
You're given credit for 2 days' time served. You're ordered to not return to 605 West Colonial Drive as a condition of your plea, and you are ordered to pay all mandatory court costs within 365 days of your release. Do you have any questions? Yes or no? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You're excused.
It's not him.
You can leave now, sir. Akeem Woods. Akeem Woods?
He's coming, Your Honor.
Okay.
He's right here. Good morning, Your Honor.
Hi, Mr. Woods. The court finds probable cause for urinating or defecating in a public place. Bond will stay set at $250 in that case.
And the offer is an adjudication of guilt, credit time served, and court costs. Mr. Woods would like to accept and enter plea of no contest. Your Honor, do you have the last 3 of the case number?
Yes, it is 920-2023-MO 920AO. Mr. Woods, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form before you signed it? Are you under the influence of any alcohol, drugs, or medication today? Yes or no?
No, ma'am.
Do you understand that a conviction on your case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
All right, sir, I've reviewed your file. There is a sufficient factual basis. You're alert, you're intelligent. I will adjudicate you guilty. And how much time served?
2 days, Your Honor.
Order 2 days in jail with credit for the 2 days you have served. Further, I am ordering you to pay all mandatory court costs in this case, and I am ordering you to pay them within 365 days of your release from incarceration. Is there no return provision? It was a public place, according to what I read.
I'm trying to understand.
No, Your Honor.
You said credit for time served as far as what? As far as I've already served the time?
Yes, you have already served at the time. I am ordering you to be released as to this charge. If there's any other case that's holding you in jail, then you may need to resolve it before you get out of jail. Thank you, sir.
He's
You, ma'am.
held on bond.
No action on the out on bond matter.
Thank you, ma'am.
Capello Crispin.
Yes, Your Honor. And there is an offer to resolve.
In that case, it's a no valid. Are you able to stipulate to a factual basis?
Yes, Your Honor. And the offer is an adjudication, credit time served, as well as court costs. You would like to accept the state's offer and enter a plea of no contest. Thank you.
Ronnie, he does have an immigration hold as well.
All right. Mr. Crispin, good afternoon, sir.
Good afternoon.
Is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read the plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine?
No.
Do you understand a conviction on this case will subject you to deportation
Yes,
if you're
ma'am.
not a U.S. citizen?
Yes.
There is a sufficient factual basis to accept your plea, and I find you to be alert and intelligent. At this time, you're adjudicated guilty in order to serve 8 days in jail with credit for 8 days' time served. Further, you must pay all mandatory court costs within 365 days of your release. Although I am releasing you as to this charge, you do have an immigration hold, and so you will not be released until the immigration hold is removed. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. You may exit.
Thank you.
Terrence Dwayne Hayward. Not present. Okay.
We got thing do not bring over.
It says Terrence Hayward.
Hughes one?
Terrence Hayward was a RR.
Okay. He's currently represented by the public defender. If he's already been released on recognizance,
Can we double check?
the public defender can,
No,
well, he
I don't
probably
have it
was
in here.
given
It's
a
gone.
date, a pretrial conference date. He probably was.
He's not here, he was RR.
Okay, so he was given his PTC date, no action since he was released on recognizance. Green Siobhan Jones. Okay.
And,
Yeah.
the offer to resolve, Ms. Jones's case, 2023 MM 359 AW, for the petty theft, Your Honor, is an adjudication of guilt, credit time served, no return to the Publix located at 8863 West Colonial Drive. There's also a cost of investigation in the amount of $169.75 to the Ocoee Police Department, as well as court costs. Ms. Jones would like to accept the state's offer and enter a plea of no contest, and defense will stipulate to a factual basis.
All right, Ms. Jones, is this your signature here at the bottom of this plea form?
Yes, yes, ma'am.
And did you read this plea form before you signed it, ma'am?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine today?
No, ma'am.
Do you understand that a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
And based on stipulation of counsel, I do find that there is a sufficient factual basis. I find that you are alert and intelligent. I will adjudicate you guilty, order 41 days in jail, credit for 41 days time served. I am ordering you to be released as to this charge. However, if you have any other cases pending that hold you in jail, you may need to resolve them before getting out of jail. I'm ordering that you not return to 8863 West Colonial Drive. Further, I am ordering that you pay all mandatory court costs as well as costs of investigation of $169.75 to the Orlando Police Department, with all monies being due and payable within 365 days of your release from incarceration. Do you have a question, ma'am?
No, ma'am, understood.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you.
Thank you.
I'm sorry, Judge, that was OPD or Ocoee?
OPD. Yes, ma'am.
For who?
Jacqueline Pisculi.
It's a Coe.
It's a Coe.
Is it Ocoee? The attorneys say it's Ocoee.
Okay.
Ms. Pisculi, in your, okay, you're here for an arraignment as well.
Yes, Your Honor, and the offer to resolve the case is a withhold of adjudication, credit time served, no return to 5991 South Goldenrod Road. There is a cost of investigation in the amount of $85.89 to the Orlando Police Department, as well as she's ordered to complete the ICC class within 60 days or D6 on her driver's license. And she would like to accept the state's offer and enter a plea of no contest.
Defense is stipulating to a factual basis.
Yes, Your Honor.
Ma'am, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this document before you signed it?
I did.
Are you under the influence of any alcohol, drugs, or medication? Do you understand that a conviction on this case will subject you to being deported if you're not a U.S. citizen? Yes or no? All right, ma'am, there is a sufficient factual basis to accept your plea. You are alert, you are intelligent. At this time, the court will withhold the adjudication of guilt, order credit for time served in the amount of 6 days, order that you not return to 5991 South Goldenrod Road, and ordering that you enroll in and complete an impulse control class and file proof of completion of that class within 60 days of your release. I am releasing you today as to this charge. However, if you have any other case holding you in jail, you may need to resolve it before you get out of jail. A failure to comply with the completion time frame for the class will result in a D6 on your driver's license. Further, you must pay all mandatory court costs and costs of investigation in the amount of $85.89 to the Orlando Police Department. Do you have any questions, ma'am?
No, thank you.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, ma'am.
Spanish, Santana?
Jose Rivera?
You need Spanish? We gotta call an interpreter. That's, it's small. I forgot.
Is there somebody you already knew?
Yes, ma'am.
I don't have her name on there. Rivera, Jose Rivera. What's next?
No, this is the petty theft, Ms. Jones.
Okay, well, which one of them needs this interpreter?
You doing it right, yes, ma'am.
Oh, okay.
Good afternoon, Your Honor. This is Laura Arroyo, State Certified Interpreter and previously sworn.
Good afternoon. This is case number 2023 MM 4075AO involving Josue Rivera. Josue Rivera, yes.
1 second, Your Honor. Let me establish connection. Connection is established.
Counsel, he's here for an arraignment.
We'll answer a plea of not guilty, Your Honor.
All right. Court will enter a plea of not guilty.
Case to be heard in Division 81. Pretrial conference is August the 4th at 9 a.m. Courtroom 6B.
Thank you. Thank you, Madam Interpreter.
You're welcome, Your Honor. The interpreter will disconnect.
Have a good day. Anthony Santana.
Good afternoon, Your Honor.
Good afternoon. In your case, you're here for an arraignment.
Yes, Your Honor. There's an offer to resolve the case with an adjudication of guilt, credit time served, no return to 455 North Garland Avenue. There's also a cost of investigation in the amount of $84 that is due to the Orlando Police Department. And defense will stipulate to a factual basis for the purpose of the plea.
Is he pleading to both count 1 and count 2?
Yes, no contest, Your Honor.
All right. Mr. Santana, sir, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read the document before you signed it, sir?
Yes, ma'am.
Are you under the influence of any alcohol or medication or drugs this afternoon?
No, ma'am.
Do you understand that by entering a plea of guilty or no contest, you are giving up all the rights on the plea form?
Yes, ma'am.
Do you understand that a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
All right, sir, there's a sufficient factual basis to accept your plea, and you are alert and intelligent. At this time, you are adjudicated guilty in order to serve 72 days in jail with credit for 72 days time served, concurrent on count 1 and count 2. I am ordering you to be released as to this charge. However, sir, do keep in mind if you have any other case holding you, you may need to resolve it before getting out of jail. I'm ordering that you pay all mandatory court costs as well as costs of investigation of $84 to the Orlando Police Department. All monies must be paid within 365 days of your release from incarceration. Further, you are ordered to not return to 455 North Garland.
Yes, ma'am. Lincoln Bus Station.
Garland and Avenue. Do you have questions, sir?
No, man. I just wanted to say y'all have a blessed weekend.
You
4th
too.
of July, yeah.
You too. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. You're excused, sir. Thank you.
Thank you, ma'am.
Rico Johnson. Mr. Johnson, the court finds probable cause for petty theft of $100 or more.
And Your Honor, there's an offer to resolve with an adjudication of guilt, credit time served, no return to 2500 South Kirkman Road. There's also a fine for $300. Okay. And Mr. Johnson would like to accept and enter a plea of no contest.
All right, Mr. Johnson, is this your signature here at the bottom of this plea form? Did you read the plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
There is a sufficient factual basis to accept your plea, and you're alert, you're intelligent, so you're adjudicated guilty and ordered to serve how much time? 2 days in jail with credit for 2 days' time served. I am ordering you to be released as to this charge. Do keep in mind, if you have any other case holding you in jail, then you must resolve that case before you get out of jail. I'm ordering that you not return to 2500 South Kirkman Road as a condition of your plea, and ordering you to pay a fine of $300 as well as all mandatory court costs. Monies must be paid within 365 days of your release from incarceration. Any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You are excused. David Robinson, sorry.
You refused, Your Honor?
Waive.
Yes, Your Honor.
All right, the court does find probable cause for both count 1 and count 2. As to count 1, bond stays at $500. As to count 2, the court will order a release on recognizance. Birddale Severance,
He also refused, Your Honor.
I'm waiving.
Could we try tomorrow, Your Honor? There's an offer to.
Sure, we can reset him for tomorrow if in case he wants to plea.
I'm sorry, why was he not here? Refusal? Thank you.
Barry Welch,
Yes, ma'am.
in your case, the court finds probable cause for trespassing.
And the offer to resolve is an adjudication of guilt, credit time served, no return to 11131 West Colonial Drive, which is the McDonald's, as well as court costs. And Mr. Welch would like to accept and enter a plea of no contest.
All right, Mr. Welch, sir, is this your signature here?
Yes, ma'am.
Did you read this plea form before you signed it?
No, ma'am.
No? Did your lawyer go over it with you, all the rights that you're giving up by entering this plea of guilty or no contest?
No, ma'am.
All right, we're gonna give it back to you, and I want you to read it on your own, unless you have trouble reading. Can you read?
Yes.
You can read? Okay, then go ahead and read that. Michael Patton. Mr. Patton. Mental health.
Could we, this is one that I was gonna have reset, Your Honor. There's actually an offer to resolve his failure to appear and trespass.
Okay, then this will be reset for tomorrow.
These are the only two I had reset.
Okay, both cases will be reset. Aaron Bowen,
Bonded, Your Honor.
previously bonded per the jail staff. Vincent Knapp,
Yes, ma'am.
yes, sir, I found probable cause for alcoholic beverages in open containers.
Yes, ma'am.
And, Your Honor, do you have the last three of the case number?
91680.
And the offer from the state is an adjudication of guilt, 3 days in the Orange County Jail with credit for 2, and court costs, Your Honor, and Mr. Knapp would like to accept and enter a plea of no contest.
All right, Mr. Knapp. Is this your signature on this plea form being handed to me? Did you read the document, sir?
Yes, ma'am.
Sir, are you under the influence of any alcohol or drugs and medicine at this time?
No, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right, there's a sufficient factual basis to accept your plea. You're alert, you're intelligent, you're adjudicated guilty in order to serve 3 days in jail with credit for how many? 2 days time served. You're also ordered to pay mandatory court costs. within 365 days of your release, and I am ordering, actually, I'm not, because you got one more day to go. Do you have any questions?
Yeah, but how many days?
It's 3 days total, and you have 2 days time served.
So I have a day yet to do?
Well, yes,
Okay.
yes,
Thank you, man.
yes. On these, cases with the 3 days, with the 2 days time served, some of these cases, I just don't understand why we're doing 3 days with 2 days time served. I'd rather just do the 2 days time served. I don't know, it seems like a bit of a necessity in ensuring justice is served. I hate to negatively impact somebody's life, especially with a minor charge like an open container. But I don't know, I guess you guys are negotiating that. Kenneth and Miller?
You don't have to accept it.
Kenneth Miller? Is that who you are?
Yes, ma'am.
In your case, sir, I do find probable cause for disorderly conduct and also probable cause for urinating or defecating in public. I'm gonna release you on your recognizance as to count 1, and as to count 2, I'll order a bond of $100.
And, would you be willing to take a bench plea? The state was offering 3 days, we would ask for credit time served.
Yes, ma'am.
And Mr. Would like to accept an enter plea of no contest.
You know, I got a day tomorrow.
How much time served does he have? Sir, I am hoping that you will get out today,
Okay, thank you.
but that does depend on if you have any other cases pending.
No, I don't.
Get out as best as I can.
Sir, is this your signature here at the bottom of this plea form?
Yes, Your Honor.
And did you read this plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or medicine or drugs?
No, I'm not.
Do you understand that a conviction on these cases will result in your deportation if you're not a U.S. citizen?
I do.
All right, I reviewed your file. There's a sufficient factual basis. You're alert, you're intelligent. I'll order 2 days with credit for 2 days time served and order you to pay all mandatory court costs. I am ordering the monies to be due and payable within 365 days of your release. I am ordering you to be released as to this charge. Just like I told you just before, if you do have other cases pending, you may need to resolve them before you get out of jail. Do you have any questions?
No, I don't, Your Honor.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Count 1 and count 2 concurrent. Yes, ma'am.
Welch is ready, Your Honor.
I think I gave you his paperwork by mistake. Mr. Welch?
Yes, ma'am.
Now, have you had a chance to read your plea form?
Yes, ma'am.
And you're ready to go forward with your plea of no contest?
Yes, ma'am.
Okay. Are you under the influence of any alcohol or drugs or medicine at this time?
No, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
And there is a sufficient factual basis to accept your plea. You are alert, you're intelligent, you are adjudicated guilty. How much time served? You're ordered to serve 2 days with credit for 2 days time served, and you're ordered to not return to 11131 West Colonial Drive, as well as you are ordered to pay all mandatory court costs associated with this charge within 365 days of your release. I'm ordering you to be released as to this charge today. However, if you have any other case holding you in jail, you may need to resolve it before getting out of jail. Any questions?
No, ma'am.
You have the right to appeal your sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Robert Joseph Shanks.
Yes, Your Honor, and I had PC challenge.
Yes, ma'am.
I would argue no probable cause to the disorderly conduct. in order for the state to prove a disorderly conduct, the vehicle must be stopped in obedience to a traffic control device based on the statute, the city statute 40, section 43.06. And based on this affidavit, there is no indication that the vehicle was stopped in obedience to a traffic control device, stop sign, or anything of that.
I'll grant that unless the state has a counter argument, because I think it's correct.
No, Your Honor.
The court does find no probable cause and releases you on your own recognizance, sir.
Thank you.
Kenneth Smith,
Yes, ma'am.
in your case, there is probable cause for possession of an open container of alcohol.
And the offer from the state is an adjudication of guilt, credit time served, and court costs, and Mr. Smith would like to accept and enter a plea of no contest.
All right, Mr. Smith, has he signed a plea form?
Yes, Your Honor.
Sir, is this your signature at the bottom of this plea form?
Yes, ma'am.
Did you read this document before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or medicine or drugs?
No, ma'am.
Do you understand that a conviction on your case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am, understand.
All right, there's a sufficient factual basis. You're alert, you're intelligent, you're adjudicated guilty. How much time served? You're ordered to serve 2 days in jail with credit for the 2 days you've served, and you are ordered to pay all mandatory court costs within 365 days of release, and I am releasing you as to this charge today. However, you may have other cases pending, and if you do, you may need to resolve them before getting out of jail. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. And thank you, sir. You can exit.
Thank you.
Marcos Raimundo Eduardomingo.
He bonded, Your Honor.
Okay. He previously bonded per the jail staff. Bridget Joe Lewis.
She bonded, Your Honor.
Bonded per the jail staff. Roberto Alexandre.
Yes, ma'am.
In your case, there's probable cause for possession of a controlled substance, and bond will stay at $500. You do not qualify for the public defender, so I'm not appointing the public defender, sir. You will need to retain your own legal counsel on your case. Thank you. Travis Brummett. The court finds probable cause for possession of cannabis less than 20 grams, and I am setting a bond of $500, taking no action on the out on bond matter.
Your Honor, for the record, it's over 20 grams.
Oh, it was over 20 grams? Oops, I'm sorry. Let me correct that, sir. I am going to stay the bond of $1,000. And my mistake, thinking it was less than 20 grams. I still take no action on the out on bond matter. David Bryan.
Cash bonded, Your Honor.
Bonded per the jail staff. Michael Burrell.
He's medical, Your Honor.
Your Honor, defense will waive. However, I would ask that you consider reducing the possession of cocaine with intent to sell. If you find probable cause, based on the affidavit, it appears this is more like personal use.
What says the state?
No objection to the reduction in bond.
All right, as to, the court finds probable cause on all counts. As to the possession of heroin, bond will stay at $1,000. As to possession of paraphernalia, the defendant is released on recognizance. As to the trespass, the defendant is released on recognizance. And as to possession of a cocaine with intent to sell or delivery, bond is set at $1,000.
He was what, medical? What was he?
Yes, medical.
Your Honor, no return?
Yes, the court orders no return. One moment on the next case. All right. I'll sure remember your name then, Sharon. David Cartagena. Ms. Cartagena, in your case, sir, I do find probable cause for count 1 and count 2. Bond stays at $5,000 for the burglary of occupied dwelling count and $100 for criminal mischief. You're ordered to have no contact with the victims and no return, possess no weapons, possess no firearms, and surrender any in your possession to law enforcement within 24 hours of release. Thank you. Tyler Cologne,
He bonded, Your Honor.
previously bonded per jail staff. Okay. Jonathan Concanon.
Yes, ma'am.
In your case, sir, I do find probable cause for count 1, burglary of an occupied conveyance while unarmed. Bond stays at $3,500. Damaging property by criminal mischief, bond stays at $100. And battery, bond is increased to $500. I'm ordering you to have no contact with the victim, no return, possess no weapons and no firearms, surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. William Green, you were picked up based on a PC warrant for failure to return some hired or leased property, and bond will stay at $2,500. You're ordered to have no contact with the victim or any employees of the victim and not to return to the location. Sebastian Guerri, the court finds probable cause for grand theft, 3rd degree of a motor vehicle. Bond stays at $1,000 and no valid license. Bond stays at $500. You're ordered to not drive.
I don't have any money to pay the bond.
One moment, sir. One last condition. You're ordered to not drive without a valid driver's license. And I'm appointing the public defender to represent you, standing right there beside you. The public defender can consult with you about your financial status and then determine what, if any, motions may need to be filed on your behalf. Thank you, sir.
Thank you.
Kevin Hawthorne. And the court, you were picked up for failure to appear.
Yes, ma'am. I
Bonds
didn't know that. Oh, I'm sorry.
stays at no bond. Thank you. Samika Ayan Hoskins.
I don't know.
Ms. Hoskins, in your case, you were, the court does find probable cause for neglect of a child. Bond will stay at $1,000. I'm ordering you to have no unsupervised contact with the child or any minor children under the age of 18 and to comply with any order of DCF that might be entered in your case. Thank you, ma'am. Jordan E. Joseph,
Bonded, Your Honor.
previously bonded per jail staff. Tony Key.
Yes, ma'am.
The court finds probable cause for aggravated battery with a deadly weapon. Bond stays at $3,500. And resisting an officer without violence, bond stays at $500. You're ordered to have no contact with the victim, possess no weapons, no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. And you're ordered to not return to the location this incident occurred at. Derek Lewis. As to fleeing and attempting to elude, the court does find probable cause. Bond is set at $4,000. State, has he been charged on the out on bond matter? I can't read this handwriting.
It's 23 CF 2326, Your Honor. He was arrested in February and formal charges have not been filed.
No action on the out on bond matter.
Your Honor, was there also a state misdemeanor?
Oh, let me see here. I missed it. Hold on a moment, sir. I have one more case in your case. Yes, sir. I do find probable cause for violation of statutes relating to state misdemeanors, and bond will stay set at $250 for that. Carl Chantel Manning. The court finds probable cause for fleeing and eluding a police officer. Bond stays at bond is set to $4,000. And resisting an officer without violence, bond stays at looks like it's 500. Bond stays at $500. Thank you, sir. Oh, wait a minute. One last thing, sir. One final thing, one moment. No, nothing, sir. Nothing else. Tyler McNeil. The court finds probable cause for aggravated assault with a deadly weapon. Bond stays at $2,500. You ordered to have no contact with the victim, no return, possess no weapons and no firearms, and surrender any weapon or firearm in your possession to law enforcement within 24 hours of your release. Thank you, sir. Joshua Mendez.
Mental health, Your Honor.
Defense will waive.
All right, defense is waiving. The court does find probable cause for all counts. As to count 1, bond stays at $2,500, 100 on count 2, and 100 on count 3. The court is ordering no contact with the victim, no return, possess no weapons, possess no firearms, and surrender any weapon or firearm to law enforcement within 24 hours of release. The court is taking no action on the out on bond matter.
So you said no contact?
No contact, no return, no weapons, no firearms, surrender. Chantel Mojita, the court finds, well, you were picked up on a PC warrant for robbery with a firearm.
Your Honor, I believe.
However, the
Yes.
only PC I saw is for robbery,
Yes, Your Honor. I think it's an error.
for which I would set a bond in this case of either $1,000 or $5,000, depending on whether the state's charging this as a second-degree misdemeanor or a third-degree misdemeanor. And I just wasn't able to tell
One moment, Your Honor.
whether it was a second or a third-degree misdemeanor.
Robbery is generally a second-degree felony, Your Honor.
It just, when I looked at it, there was also a charge of where a robbery could be, a robbery with no weapons by sudden snatching could be a third-degree misdemeanor. I don't know what this is. There were no weapons involved.
No.
Clearly, the robbery with the firearm charge is invalidated.
Your Honor, she appears to have no history. State would have no objection to a $1,000 bond.
All right, the court does find probable cause for robbery only, and I am ordering that you have no contact with the victim, and that you pay a bond, post a bond of $1,000. Trying to remember what location, there was a couple of locations. I don't remember if it was the victim's home or her home.
Don't talk.
Or near the victim's home or near her home. I'm gonna order no return. No return to the location where this incident occurred. Yes. Ma'am, even though I found probable cause just for simple robbery, I am ordering you possess no weapons and no firearms as a condition of your release, and surrender any weapons or firearms to law enforcement within 24 hours of release. All right, thank you, ma'am. Tracy Montgomery.
And defense will waive, Your Honor, and I would ask that you ROR as to the resisting an officer without violence. They charged him with 3. And they're all stemming from the same incident, as well as 2 of the resisting and officers with violence. They all stem from the same incident. And the
So let me just, I'm in agreement with the resisting with the officer without violence, but I'm not sure what's the state's position on the resisting an officer with the violence? It seems like to me he only hit one person or kicked them in the chest, but the activity was violent. And I don't know if the law authorizes to charge it for every officer that was present or just the officer that actually had the violence physically.
It should just be for the one officer, Your Honor.
All right, so then that motion's granted. I am finding probable cause as follows. Count 1, resisting an officer with violence, bond stays at $1,000. Count 2, battery on an officer, I'm actually increasing that bond to $2,500. Count 3, resisting an officer with violence, no PC. And,
Your Honor,
yes, ma'am.
Okay, no, that's fine. I apologize.
No PC, the defendant is released on recognizance. Count 4, resisting with violence, no PC, defendant is released on recognizance. 2,500. Yes, ma'am, I increased count 2. That's the battery on an officer charge. The next count, resisting without violence, bond is reduced to $100. And the next count, possession of a controlled substance, bond is reduced to $100. And the next, resisting an officer without violence, no PC.
Your Honor?
Yes, ma'am.
It's not that there's no PC, it's just that the state doesn't go forward or cannot go forward on more than one. But he did resist more than one officer, so generally.
That's just to the misdemeanors?
Yes, Your Honor.
Okay.
Yeah, so generally what they do is they just ROR.
Okay.
There is PC.
Okay, as to the misdemeanor, resisting, well, I'll go back and do it by counts. As to count, oh my God, Madam Clerk, I guess I'll do it by what it's called. As to the first, resisting an officer without violence, bond is set at $100. Then there are 2 other resisting an officers without violence, and I am ordering release on recognizance and finding probable cause on both of those. Now, does that clear that up and include every single count?
Yes, Your Honor.
Or do we need to go back over it? So have I got to the milk crate case yet? No, this isn't a milk crate case.
No, Your Honor.
Because I can't wait to get to the milk crate case and we can talk about the milk crate. Because I have some questions about that case. But I thought this was the milk crate case.
She felt she was behavior, what was it? Why she didn't show? Behavior.
You got it, Sharon? All right. All right, thank you. Romelio Nazanor?
Behavior also, Your Honor.
Defense will waive.
The court finds probable cause for possession of methylene, MDMA, ecstasy, bond stays at 1,000, and resisting an officer, bond stays at 500. Michael Paul. The court finds probable cause for possession of 3,4-methylene, MDMA, ecstasy, and bond stays at $1,000. Thank you. Tanisha Pinson. The court finds probable cause for possession of 3,4-methylene, MDMA, and ecstasy, and bond stays at $1,000. The court, the facts on this next case, the court finds probable cause for possession of open container or alcoholic beverages. So does this case, are these 2 cases related? Because this, I didn't look at the date, but if they're related, then there is no second charge. But if they're not related, then there's another charge of possession of MDMA, ecstasy.
It's the same.
It's the same? Okay. All right. Per the defense, it's the same, so that's fine.
And
the court does find probable cause for the possession of alcohol. Bond is set at, resisting an, Release on recognizance, y'all. It's a long day. It's been a long day. Sharon? It's been a long day. My back's hurting. Julio Rivero Moya. It hurts. That's why I'm leaning forward. Possession of cocaine, the court finds probable cause, bond stays at $1,000. Possession of a controlled substance.
Your Honor, I was trying to figure out what the controlled substance was.
The court does not find probable cause for the second count and was intending to release the defendant on recognizance. And possession of paraphernalia, I do find probable cause and release the defendant on recognizance unless the state wants additional time on count 2.
No, Your Honor.
All right, thank you. Anthony Rodriguez Rivera. As to fleeing and attempting to elude an officer with the lights and siren, the court finds probable cause and bonds is set to $4,000. What's the status on the out on bond case, Madam Prosecutor?
His pretrial set for July 12th.
So that charge has actually been filed?
Yes, Your Honor.
And these are 2 felonies?
Yes, Your Honor. It's 2 counts of carrying a concealed firearm.
All right, the court will revoke the bond on count 1 and count 2 and order a new bond of $5,000 on count 1 and $5,000 on count 2. On the out on bond case number 2023 CF 2023 CF 354 AL. Thank you, sir. Lawrence Rouse. Mr. Rouse, the court finds probable cause for possession of 3,4-methylene MDMA ecstasy, and bond is stayed at $1,000. Thank you, sir. Could he hear?
He said he didn't hear anything.
Oh, let me have that back. Sir, can you hear me better now?
Yes, okay.
All right. I find probable cause for possession of 3,4-methylene MDMA ecstasy. Bond stays set at $1,000. Do you understand now? Yes or no? Yes. Thank you. Wesley Rush. Mr. Rush.
Yes, ma'am.
The court finds probable cause for burglary of a conveyance. Bond stays at $3,500, as well as assault. Bond stays at $500. You are ordered to have no contact with the victim, no return, possess no weapons, possess no firearms, surrender any weapons or firearms to law enforcement within 24 hours of release. I actually did look at this case, the out on bond matter, and it looks like it has not been charged. Am I correct, State?
Yes, Your Honor.
All right, no action on the out on bond. Thank you. Tremaine Skinner.
Bonded, Your Honor.
Bonded per jail staff. Matthew Zinn. The court finds probable cause for possession of cocaine. Bond stays at $1,000. And count 2, possession of 3,4-methylene MDMA ecstasy. Bond is reduced to $500. And possession of drug paraphernalia, count 3. Bond is reduced to release on recognizance. Thank you, sir. Lionel Wilkerson.
Yes.
In your case, you were picked up on a probable cause warrant for second-degree murder, and bond will stay at no bond. You're ordered to possess no weapons or no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release.
You say what? No bond?
Yes, sir. No bond.
Why can't I have a bond?
The judge is ordering no bond.
But I go to a bond here and say, can I get a bond?
I'm appointing the public defender to represent you, And you can consult with the public defender about filing any type of a motion regarding, release conditions or changing release conditions. Okay, well, so we didn't do the sitting on the milk crate case.
I think we
The next
passed it
one.
already. Is it?
No, it's
Oh.
this one.
Oh, okay.
Oh, it's this next one. Okay, Thomas
Oh, yeah,
Williams.
it's right here.
So I looked at that statute because I've never had that charge before. Possession of a grocery cart or dairy case, and in this case, it seemed to be a milk crate or dairy case. So it says in the statute that, it has to have a registered name or mark. And then if it has a registered name or mark, then the defendant shall be presumed to be in possession of stolen property. So I didn't see where it had a registered name or mark. I read it twice. I may have missed it, but, I would say it's the state as to whether or not there was some information about it having a registered name or mark.
No, Your Honor, I did not see that either. It just said that it was a dairy crate.
All right, well, I do find probable cause for count 1, and bond is stayed at 500. As to count 2, I do not find probable cause, and I am gonna release you on your recognizance as to count 2. And then in your other case, I think there were 2 cases. Yes, here it is. The court finds probable cause for count 1, possession of methamphetamine with a weapon. Bond stays at $15,000. Carrying a concealed weapon by a convicted felon. Bond stays at $5,000. Possession of ammunition by a convicted felon. Bond is reduced to $1,000. Possession of ammunition by a convicted felon. Bond is reduced to $500. Possession of ammunition by a convicted felon. Bond is reduced to $100. Possession of ammunition by a convicted felon. Bond is reduced to $100. Possession of cocaine less than 20 grams. Bond is reduced to $100.
Your Honor, that's
Cannabis, Your
cannabis.
I'm sorry, it's cannabis. Bond is reduced to $100. Which one of you said it first? I mean, it was like a Jeopardy game or something. I mean, who wants the award?
Defense.
All right, the defense got it first. I heard 3 people say it. Okay. Thank you, sir.
Your Honor, there's an out on bond.
I did not look at the out on bond case, so state, you'll need to let me know if that case is, was it charged yet? He does have an ROR.
No, Your Honor, it has not been filed on.
No action on the out on bond. You guys really did sound like you were like a Jeopardy contestant, or, yeah, it would have to be Jeopardy because Family Feud doesn't play like that, does it? It doesn't play like that. So it's a Jeopardy. Wait a minute, what, no, it is, Family Feud does play like that, doesn't it? Where everybody gets to answer the first one when they first come out?
Yes.
Yeah.
One. I guess we can sign the other ones tomorrow.
Well, I'll be here on Wednesday, because as you know, tomorrow's a holiday. Anything else on the record?
Let me see.
Me later.
Tyrone, anything else on the record, or can I?
Nothing from state.
All right, court stands on recess.